Hello and welcome to our general informational webinar about human rights laws in BC. The Vancouver Island Human Rights Coalition, or VIHRC for short, is a nonprofit organization located in Victoria on the Coast Salish territories. At VIHRC, advocates provide legal information and advocate for people or groups who may face discrimination. They also assist people to resolve their discrimination-related issues informally and assist people with filing complaints before the BC Human Rights Tribunal, as well as deliver presentations on human rights in BC generally. If you have any questions about discrimination or human rights laws in BC, you can contact us by phone or email. For more information, you can visit our website and follow us on Facebook and Twitter. The purpose of this webinar is to provide you with a general overview of the human rights system in BC. We will cover what is protected by the BC Human Rights Code, which is what's known as anti-discrimination law. We'll also cover the personal characteristics and areas of protection. We'll wrap up by discussing what you can do if you face discrimination, specifically the process of filing a human rights complaint before the tribunal. So now we're going to talk a little bit about the human rights landscape in BC. The BC human rights system is comprised of three components. First, there's the BC Human Rights Tribunal, which is like a court. The tribunal hears, mediates, and decides human rights cases. We'll talk a little bit more about the tribunal in the next few slides. Second, there's the BC Human Rights Commissioner. Their job is to investigate systemic human rights issues in BC and advocate for reforming unjust and discriminatory laws, policies, practices, and cultures. They do this through education, research, advocacy, inquiry, and monitoring. Lastly, there's the BC Human Rights Clinic. This is an independent human rights legal aid organization located in Vancouver. The clinic provides free representation and legal services to people in BC who need help with their human rights complaint before the Human Rights Tribunal. They also provide free and low-cost educational workshops and training seminars. Human rights in Canada are protected at the federal level by the Canadian Human Rights Act. This protects people from discrimination when they are employed or receive services from the federal government. At the provincial level, each province has its own human rights code and tribunal. In BC, this is called the BC Human Rights Code. The code prohibits discrimination based on certain personal characteristics in certain areas of daily life. It doesn't protect against all discrimination, however, and doesn't cover purely private interactions. The 5 areas where a person receives protection from discrimination in the code are: first, employment. This includes all stages, such as job interviews, the hiring process, and termination. Second, housing. This includes the purchase of property and tenancy. Third, labor unions, which are organizations that act as an intermediary between their members and the employer. Fourth, publications. And finally, public services like schools, stores, restaurants, and recreation centers. The BC Human Rights Tribunal is an independent administrative body responsible for dealing with complaints under the code. Under the Human Rights Code, we are all protected against discrimination in the 5 social areas mentioned. But what does discrimination mean in the context of the Human Rights Code? Here's a definition that we at VIHRC find useful. Discrimination occurs when someone is treated differently because of their personal characteristics and it affects them negatively. Discrimination in BC involves 16 different personal characteristics or attributes under the code. As you can see, the code prohibits discrimination on several grounds related to race. These include mainly the grounds of race, ancestry, place of origin, color, and religion. Depending on the circumstances, discrimination based on race may cite race alone or may include one or more related grounds. More specifically, race includes socio-cultural or ethnic groups such as First Nations, Métis, Chinese, or South Asian. Ancestry includes where a person's family is from. Examples include Aboriginal, Cree, Bosnian, Filipino, or Persian ancestry, as well as many more. Place of origin includes the fact of being born in a particular country or region of Canada or the world. Gender identity is a person's sense of their gender, including man, woman, transgender, or non-binary. For some people, gender identity is fixed. For others, it is fluid. Gender expression is about how a person presents their gender. It includes how a person acts and appears. It can include dress, hair, makeup, body language, and voice. How a person presents their gender may not reflect a gender identity. Gender identity or expression can also include a person's name and pronoun, such as he, she, or they. Sexual orientation includes being heterosexual, gay, lesbian, or bisexual. Sex includes being female, male, intersex, two-spirit, or transgender. Sex also includes pregnancy, breastfeeding, and sexual harassment. Age means 19 years or more. Distinctions based on age are not discrimination if they are permitted or even required by legislation or regulation. The code allows some differential treatment based on age, such as seniority schemes, certain employment benefit or pension plans, and insurance premiums or benefits. Family status includes being related to another person by blood, marriage, or adoption. It includes family type, for example, a single parent family, and who is in your family. Examples of possible discrimination are denying a service because the shop owner dislikes the shopper's father, and hiring a family member who is no more qualified than other applicants. Family care obligations may also be protected where there is a serious interference with a substantial parental or family duty. For example, it might be discrimination if an employer changes someone's hours of work, making it impossible for them to provide care for their children. Marital status includes being married, single, widowed, divorced, separated, or living common law. It also includes who your spouse is. So, for example, if a person is refused a service because of who their partner is or because they're single, it could be discrimination based on marital status. Mental disability includes such conditions as learning disorder, developmental disabilities, or illnesses based on or including depression or bipolar disorder. For example, it is discrimination to fire an employee based on a concern that they are at risk of developing a disability, either physical or mental, that might affect their abilities. Physical disability includes conditions that impair a person's ability to carry out the normal functions of life. This includes addiction, amputation, asthma, acne, diabetes, cancer, epilepsy, high blood pressure, hypertension, obesity, and impairments to mobility. It includes people who are deaf, hard of hearing, or blind. However, it does not include short-lived conditions such as a cold. Political belief includes support of a political party or group that advocates political change and beliefs about the organization and governments of communities. It includes advocacy for a change to legislation. This is only protected in the areas of employment, employment advertisements, and membership in a union or occupational association. Source of income refers to legal sources of income. It is only protected in the area of tenancy. For example, a landlord should not refuse to rent to a person because their source of income is income assistance, disability pension benefits, or rent subsidies. Criminal conviction includes being charged with or convicted of an offense under the criminal code or another law. It is also only protected in the areas of employment and membership in a union or occupational association. It is important to know that the code does not prohibit discrimination if the criminal conviction is related to the person's employment or intended employment. There are two other important things to keep in mind when interpreting the code. First, a single comment, even if discriminatory, may not violate the code. Second, intention doesn't matter. This means that a person can discriminate even if they don't mean to. For example, consider a situation where an older man applies for a job at a trendy women's clothing store. The young woman who interviews him finds him pleasantly similar to her favorite grandfather and tells him this is a compliment. Later, the man is told that he didn't get the job because he does not have the right qualifications and the person they decided to hire had more energy. This could be discrimination based on age, depending on the full context of the situation, even though it's not clear that the interviewer preferred anybody else. And it was clear that she liked the man on a personal basis. Differential treatment is also not always prohibited. Sometimes there are justifications to treat people differently. Some other times, although discrimination is not justified, it won't be protected by the code. Let's look at some examples. A teenager being refused to sell alcohol. This is differential treatment based on age, but there's an objective justification to the rule. It's done for health purposes and to protect youth under 19 in BC. So this differential treatment has determined to be a good thing and therefore not discriminatory. Or a situation where a landlord refuses to rent to a family because they have a child. In the area of tenancy, this would be discrimination based on family status. Landlords cannot refuse to rent a place to a family simply because they have children. It's worth mentioning, however, that family status is not a protected ground with regards to the purchase of property. So if they were trying to buy the property, it might not be considered discrimination. How about a situation where a building is only rented to seniors of 55 or older? According to the BC Human Rights Code, landlords cannot discriminate against tenants or potential tenants based on personal characteristics except in specific circumstances. One such special circumstance is retirement or older living communities. This is clearly differential treatment, but it's justified by the specific exemption that is set out in the BC Human Rights Code. An Indigenous center that only hires Indigenous peoples. Sometimes there are what are called special programs that benefit a certain group of people that have faced historical disadvantages, much like Indigenous peoples, and so the same group of people are preferentially hired. This kind of discrimination, or differential treatment, is justified via the specific exemption in the BC Human Rights Code. The purpose for this kind of differential treatment is to improve the conditions for that disadvantaged group. Lastly, a family being harassed by their neighbor with racist slurs. This is clearly discrimination, but since it's a purely private interaction, it doesn't fall into one of the 5 areas that are protected by the code. In this situation, the family cannot file a human rights complaint before the tribunal. However, there are protections under the criminal code for these kinds of situations, so the family could report the incident to the police. So far, we've covered examples of what is known as direct discrimination, but discrimination can take many forms. In some cases, discrimination may be indirect. Indirect discrimination takes place when a practice, policy, or rule that applies to everyone in the same way has a negative effect on some people. This puts them at a particular disadvantage, even though there was no intention to do so. To avoid indirect discrimination, then, it's sometimes necessary to focus on equity rather than equality. So equality would be treating everybody the same. This aims to promote fairness, but it can only work if everyone starts from the same place and needs the same help. Equity is giving everybody what they need to be successful. And this sometimes involves differential treatment to overcome negative outcomes. So let's look at a specific example to help understand this better. Last Saturday, Michael and his friends attended a movie theater they'd never been to before. The theater staff told Michael, who uses a motorized wheelchair because he has muscular dystrophy, that he would either have to transfer into a theater seat or watch the movie from the only area available for his wheelchair, in front of the first row of seats right near the screen. When he complained about this arrangement, the theater staff told him that he was entitled to the same service as everybody else, a ticket and a seat to watch the movie. Has the movie theater staff violated Michael's human rights? The answer would be yes. The theater has discriminated in providing services on the ground of Michael's disability. This exact situation is actually based on a real case where a court said that treating people the same does not necessarily provide equal results. In this case, the theater would argue that it had provided Michael with the same services as all other customers, a ticket and a seat, and they had no intention of discriminating against him. However, Michael's lawyers could argue that unlike other customers, he could not take any seat in the theater. His disability meant that he could not transfer out of his wheelchair into the theater's seats. Meanwhile, the area offered to him in the front row of seats was restricted and inferior to the range of seating offered to other people. The court found that even though the theater management had not intended to discriminate, their actions had a discriminatory effect on Michael. Again, the focus here is on the impact on the complainant, not the intent of the respondent. So now the duty to accommodate. Sometimes people need individual arrangements so they can do their jobs, to access services and buildings, and to enjoy housing equally. These arrangements are called accommodations, and they can be based on any code ground, like disability, religion, family status, or sex. The duty to accommodate means that sometimes it's necessary to treat someone differently in order to prevent or reduce discrimination. The duty to accommodate recognizes that some people might need to be treated differently to have the same opportunity that others receive from usual policies or practices. This is particularly clear in the context of the workplace. According to the duty to accommodate, employers are obligated to consider how their design and management of their workplace will impact different groups. This includes anybody with characteristics that are protected by the BC Human Rights Code. If an employee faces a barrier that prevents them from fully participating in the workplace, the employer must provide reasonable accommodations, short of causing them undue hardship. So each accommodation is assessed on a case-by-case basis. Examples of what might be considered reasonable include improving building access, modifying workstations or uniforms, adjusting working hours or job duties, and creating inclusive washrooms. Accommodation is a shared responsibility between the employer and the individual in need. To receive accommodation, it's important to let the employer, landlord, or service provider know about your condition, such as an injury or disability. This often requires that you provide evidence of your specific needs, usually in the form of a medical note. It's also important to be collaborative and reasonable in your expectations and to accept appropriate accommodations. After all, the duty to accommodate protects reasonable accommodations, not perfect ones. If you cannot solve the problem informally, one option is to file a human rights complaint before the BC Human Rights Tribunal. Complaints must be filed within 1 year of the discrimination occurring, though there are some exceptions where the discrimination continues over an extended period of time. Filing a complaint is free, and you do not need a lawyer to represent you. If you want some support with filing a complaint, advocates at VIHERC will help you out. When filing a complaint, you have to fill out one of the tribunal's complaint forms. This asks you to describe what happened, who you are, and who you're complaining about. It's important to be as detailed as possible. This involves including the dates that the discrimination happened, where it happened, what happened specifically, and how the discriminatory behavior is connected to one of your personal characteristics. You should also keep copies of any evidence that you might have, since this will be needed later in the process. The complaint form will also ask you to say if you are interested in trying to resolve the complaint early on in the process via a mediation. You have this option to choose to resolve the issue with a neutral mediator, and that means that you won't need to go to a hearing with the tribunal. However, this is optional, and if a settlement cannot be reached, then the complaint can always proceed to a hearing later. If you do wind up going to a hearing, a tribunal member will hear your case. They are much like a judge and will offer a final decision on the matter. If the tribunal member finds that there was discrimination, they will order a remedy, which usually takes the form of one of the following: to stop the discrimination, to give you back the right or the opportunity that the person denied you, to pay for actual financial losses, such as wages or moving costs, and to pay you compensation for hurting your feelings or injuring your dignity. That's it for the webinar. If you have any questions, concerns, or want help filing a complaint, please contact VIHERC via the contact info listed at the beginning of the presentation. Thank you for listening, and be well.